Chapter 6, Saving and Repeals, Section 29 to 30. Interim maintenance claim by husband and wife during the pendency of matrimonial proceeding is called maintenance pendent light. In the absence of any proceeding under Hindu Marriage Act between parents of the children, an order for custody, maintenance, and education of minor children can be passed by district court. In a suit for dissolution of marriage, both maintenance pendent light and permanent alimony can be granted. A Hindu wife may not claim maintenance from her husband on which one of the following grounds after divorce granted. During the pendency of appeal against the decree of divorce, the parties are not competent to contract another marriage and there is incapacity to do so is absolute. An order under Section 24 of Hindu Marriage Act 1955 is an interlocutory order and no appeal lies against it. State the new right of wife to file the petition before district court within local limit of whose civil jurisdiction she is residing on the date of presentation of petition. A divorced Hindu wife can claim maintenance under which one of the following act: Hindu Marriage Act and Criminal Procedure Code. Miscellaneous marriage between party within degree of prohibited relationship, void. Impotency, voidable. Marriage between two supined of each other, void. Pregnancy of wife at the time of marriage by some person other than the petitioner, voidable. Who among the following define Hindu law as Hindu law of Smriti? Maini. In which one of the following case it was held that matrimonial rights are not violative of Article 14 and 21 of the Constitution of India? Saroj Rani versus Sudarshan. In which one of the following case it was first time held that Hindu is by birth and cannot be made? Ibrahim versus Ibrahim. Premarital relation of the spouse is statutory ground for none of the above. A bigamous marriage contracted before the commencement of the Hindu Marriage Act 1955 remains valid. The case relating to constructive desertion is Jyotish Chandra versus Meera. The Hindu Marriage Act 1955 came into the force on 18 May 1955. If a Hindu boy marry a Hindu girl of the same Gotra under Hindu Marriage Act 1955, the marriage is valid. Which one of the following theories is the outcome of the fundamental shift in the policy discernible from the judicial recognition of the view that the purpose of the divorce law was not to punish the guilty but to protect the innocent spouse? Breakdown theory. In explaining unsound mind, a ground for seeking divorce under the Hindu Marriage Act 1955, in which one of the following case Supreme Court held that a sound mind indisputable is a key to the happy married life. Sarad versus Dharampal. While examining the amplitude of cruelty for the purpose of Hindu Marriage Act 1955, the Honorable Supreme Court, in which one of the following case laid down broad parameters which may be relevant in dealing with the cases of mental cruelty. Samar Ghosh versus Jaya Ghosh 2007, in which one of the following act has fixed for minimum age of marriage of boy and girl. Child Marriage Restraint Act, Hindu Marriage Act, Special Marriage Act. Adultery by the Hindu husband is ground of divorce and judicial separation both. In India, a decree for restitution of conjugal right can be executed by attachment of property of the respondent. Hindu husband converting to Islam and marrying again will be the guilty of bigamy. It was held in which one of the following cases? Sarla Mugdal versus Union of India. Under Hindu law, where the husband creates a condition in which the wife is compelled to leave the conjugal home and live separately, the husband is guilty of constructive desertion. Law relating to the marriage among the Hindu has been codified under Hindu Marriage Act 1955, in which one of the following reports the Law Commission recommended the breakdown principle to accepted the additional ground as a divorce. 71st report. Rule relating to supine relationship is based on the principle of exogamy. Match impotency. Section 12 1A. Registration of marriage. Section 8. Pre-marriage pregnancy. Section 12 1D. Incapacity to consent mental disorder. Section 12 1B. Hindu dies intestate, leaving behind two sons, one daughter, and widow. His property shall be devolved to son, daughter, and widow all. Hindu Minority and Guardianship Act is not applicable to scheduled tribes unless notified by central government, renunciates of Union Territory and Pondicherry. In which one of the following cases the Supreme Court held that the demand of dowry, which is prohibited under the law, amount to cruelty, also a ground of dissolution of marriage. Shobha Rani versus Madhukar Reddy. In which case Supreme Court held that staying together under the same roof is not precondition of mental cruelty. K. Srinivasan Rao versus D. A. Deepa. Voluntary sexual intercourse outside the wedlock is ground for judicial separation, as well as divorce under Hindu Marriage Act 1955. Apart for being sued, divorce or judicial separation, a spouse having voluntary sexual intercourse outside the wedlock is also punishable under 497 of Indian Penal Code. As such, this act is necessary amount to adultery. First statement is right, another is wrong. The leading case of Hindu husband entering second marriage on conversion of Islam is Sarla Mugdal case 1995. Supreme Court in Sarla Mugdal versus Union of India laid down the conversion of a Hindu husband to Islam. He cannot marry again till his pre-conversion Hindu marriage is dissolved as per Hindu law. Which section of the Hindu Marriage Act 1955 provide for condition of marriages? Section 5. Which one of the following ancient form of marriage was not approved by Hindu law? Gandharv and Ashur. If the party to the Hindu marriage are supine to each other, the marriage is void. Hindu marriage is valid enough, though Consent of the party to the marriage were not taken. Which one of the following is not requirement of the valid Hindu marriage? Consent of the parties to the marriage. Which one of the following is not a condition of Hindu Marriage Act 5 under section 5 of the Hindu Marriage Act? Both are subpoenas. A Sikh solemnize a marriage to the Buddhist cult as per Hindu law ceremony. The marriage is valid.